X hired Y as her driver for her daily commute to work. One Monday, X woke up an hour late. To get to work on time, she instructed Y to step on the pedal and drive fast. She also threatened to fire him if she got to work late or if he damaged her brand new car during the drive. Afraid to lose his job, Y beat a red light along Osmina Avenue. As a result, he hit a motorcycle, resulting in the death of the motorcycle driver. The bereaved family of the victim sued both X and Y for damages. X raised the defense that she was merely a passenger. As such, she could not be held liable for Y's negligence. Is X correct? Reasons. X is not correct. Under Philippine law, X can be held liable, solidarily with Y, for the death damages caused by Y's negligent driving. Under Article 2176 of the Civil Code of the Philippines, those who by act or omission cause damage to another, through fault or negligence, are obliged to pay for the damage done. Under Article 2180 of the Civil Code, employers shall be liable for the damages caused by their employees in the performance of their duties. Thus, if an employee, in the course of his employment or while performing tasks for his employer, commits a negligent or wrongful act, the employer may be held liable solidarily with the employee for damages. Under jurisprudence, the registered owner of a vehicle may also be held liable for damages caused by its operation, along with the driver and employer. Given the facts, X hired Y as driver. For her daily commute to work, there is an employer-employee relationship. On the occasion, X instructed Y to step on the pedal, to drive fast, threatened to fire him if X arrives late or if he damaged the brand new car. These are commands/directions from employer to employee in the course of performance of duties. Y, under instruction, beat a red light and caused death of third party. This act was committed in the performance of Y's work as driver for X. Thus, the negligent act is within scope of Y's employment. Being a passenger in the vehicle does not ipso facto relieve her from vicarious liability if she instructed the driver, hired him, had control over his performance, and the act was done in fulfilling her directives. The notion of mere passenger suggests lack of control or direction, but here X gave direct instructions, drive fast, threats, etc., which show control over manner of performance. Article 2180 does not require the employer to always physically be commanding at every moment, but that the act be in performance of the employment duties and under the authority or control, express or implied, of the employer. The giving of instruction to drive fast to arrive on time is consistent with employer's authority. Therefore, X is not correct. Under Philippine law, X can be held liable, solidarily with Y, for the death damages caused by Y's negligent driving. On March 15, 2025, A and B got married before Judge C as the solemnizing officer inside her chambers in the Regional Trial Court for Makati City. Unknown to both A and B, Judge C was dismissed from the service by the Supreme Court on March 14, 2025 due to grave misconduct. Judge C was only able to gain access to her chambers on the day of the wedding to collect her things. What is the status of A and B's marriage? Reasons. The marriage between A and B solemnized by Judge C on March 15, 2025 is valid. Under Art. 35. 2. The following marriages shall be void from the beginning. Those solemnized by any person not legally authorized to perform marriages, unless such marriages were contracted with either or both parties, believing in good faith that the solemnizing officer had the legal authority to do so. Here, Judge C had been dismissed the day before, March 14, 2025. On March 15th, she was no longer a judge, so she had no authority to solemnize marriages under Article 7. But this fact was unknown to both A and B. They did not know Judge C had been dismissed. They believed in good faith that she was still a judge authorized to solemnize. Thus Article 35(2) S exception applies. Therefore, the marriage is valid because both parties contracted in good faith belief in the authority of the solemnizing officer. A died intestate and without any ascendants, descendants, and surviving spouse. A was survived by B, his cousin, and C, his sister. Can B demand from C to split A's estate in half? Reasons. No, B cannot demand half of A's estate. The Civil Code provides the order of intestate succession. Art. 978. Legitimate children and descendants succeed first. Art. 984. If the decedent leaves no descendants, ascendants, or illegitimate children, the surviving brothers and sisters and their descendants inherit. Art. 1003. In default of the above heirs, the nearest collateral relatives, up to the 5th degree, succeed. Preference of nearer relatives over more remote ones. Art. 962. Civil Code. Relatives of the nearer degree exclude the more remote, saving the right of representation when it properly takes place. Since A died without descendants, ascendants, or a spouse, the collateral relatives inherit. Under Art. 984, the surviving sister C is entitled to inherit A's estate in full. B, as a cousin, is a relative of a more remote degree, 4th degree collateral. By Art. 962 C, as a nearer heir, 2nd degree, excludes B entirely. Therefore, B cannot demand half of A's estate. A. and B got married in 1991 without a prenuptial agreement. In 1997, a forged B's signature on the promissory note covering the loan she obtained from P Commercial Bank, PCB, for her printing business. She also forged his signature on the real estate mortgage constituted over 3 parcels of land which were acquired during their marriage. A subsequently failed to pay the loan, so PCB foreclosed the mortgage. The 3 parcels of land were sold to PCB, the highest bidder. Upon learning of the mortgage and sale, B filed a complaint to nullify the real estate mortgage and cancel the certificate of sale, contending that the same were void since he did not consent to the real estate mortgage. Is B correct? Reasons. Yes, B is correct. The real estate mortgage constituted by A over the 3 parcels of land is void. Under Article 96 of the Family Code, dispositions of community property require the written consent of both spouses. Otherwise, they are void. Since A and B married in 1991, the governing regime is the Absolute Community of Property, ACP, under the Family Code, effective August 3, 1988, absent a prenuptial agreement, Art. 75 Family Code. The 3 parcels of land were acquired during the marriage. Thus, they form part of the absolute community of property. For their valid encumbrance, mortgage, consent of both spouses is mandatory under Article 96. Here, a forged B's signature. Forgery renders the supposed consent non-existent. There was no authority from B nor from the court authorizing A alone to encumber the property. Hence, the real estate mortgage is void. The foreclosure and subsequent sale to PCB, being derivative of a void mortgage, are also void. C inherits A's estate in its entirety. A was a public school teacher in XYZ Elementary School. She applied for and was granted several loans on various dates by the Government Service Insurance System, GSTS, amounting to PHP 147,000.00. In 2020, she retired from the service. She was subsequently informed by the GSIS that her loan accounts were considered to have been fully settled after her unpaid loans and interests, amounting to PHP 638,172.59, were deducted from her retirement benefits. It turned out that GSIS imposed interest on arrears equivalent to 12% per annum compounded monthly and a penalty, equivalent to 6% per annum compounded monthly on A's loans, leading to the increase of her outstanding loan by 432.135% from the original amount. Failing to obtain a favorable ruling from the GSTS, A went to court, seeking to reduce the interest on arrears and penalties for being unconscionable. Is A's argument meritorious? Reasons. Yes, A's argument that the interest is unconscionable is meritorious. In Clarita D. Aclado v. Government Service Insurance System, GR number 260428, March 1, 2023. The Supreme Court granted the petition of a retired teacher and ruled against GSTS as to the manner and extent of interest and penalties charged. The SC ordered GSTS to waive the 12% interest on arrears, to charge only the 6% penalty from the date of first collection notice, and to refund any excess amounts improperly deducted from the petitioner's retirement benefits. The decision recognizes that compounded monthly interest plus penalty that produces an interest on interest on interest result may be shocking to the conscience and thus subject to judicial correction. On facts substantially analogous to Aclado v. GSIS, GR number 260428, March 1, 2023. The Supreme Court found Size's combined practice of charging 12% PA interest on arrears compounded monthly plus 6% PA penalty compounded monthly to be unconscionable in application and ordered equitable relief, waiver of the 12% arrears interest, limiting the 6% penalty to date of collection notice, and refund of excess deductions. Given A's massive increase of obligation is almost equal to 432%, and the fact pattern you gave, retiree, GSTS deductions consuming retirement proceeds, a court should, and under Aclado likely will, reduce or waive the unconscionable components and order appropriate refund/adjustment. Therefore, yes, A's argument that the interest is unconscionable is meritorious. A entered into a contract of sale conveying a house and lot in favor of B. Unwilling to pay thousands of pesos for notarization fees, A and B decided not to have the contract of sale notarized. B nonetheless made C, her nephew, a second-year law student, check the contract. C informed his aunt that the sale was void because it was not in a public instrument. He thus advised her to file a case in court to declare the contract of sale void. Is C correct? Reasons. C's advice is incorrect. I in estate of Pedro C. Gonzalez versus heirs of Marcos Perez, GR number 169681, November 5, 2009. Citing the established principle that the absence of a public document, as required by Article 1358 of the Civil Code, does not invalidate the contract between the parties, the court said, an unnotarized sale of an immovable property is valid between the parties. The form requirement is for convenience and registration purposes, not for the contract's basic validity. The sale of the house and lot, even if not notarized, remains valid between A and B because the Civil Code does not require notarization as a condition for validity. What is affected is enforceability. A It cannot prejudice third parties unless in a public instrument and duly registered. And b. Proof in court may be limited because an unnotarized contract is merely a private document that must be authenticated before admission as evidence. Thus, C is incorrect in stating that the contract is void. At most, she could seek notarization later or compel A under Art. 1357 to execute the proper form. A. Leased out his condominium unit for 10 years for PHP 50,000.00 a month. Meanwhile, A harbored his mistress X in his house while his wife, B, was in the United States of America. Subsequently, A donated to X the right to receive all rentals from the lessee of the condominium unit. B filed an action to declare the donation void as it was made between A and X who are guilty of concubinage. In their defense, A and X claimed that the action should be dismissed since the crime of concubinage should first be proved in a separate criminal case. Decide with. Reasons. The donation is void. Article 739, Civil Code, expressly lists donations between persons guilty of adultery or concubinage as void, and it states that the guilt of the donor and donee may be proved by preponderance of evidence in the same action. Family Code. Article 87. No spouse may donate to his or her paramour or concubine during the marriage. Such donations are void. Insular Life Assurance Company, Limited v. Ebrado, Gr. No. L. 44059, October 28, 1977. The Supreme Court applied Article 739 and stated that a conviction for adultery/concubinage is not required before the disabilities in Article 739 may take effect. The civil forum may determine the guilt for purposes of invalidating donations/testamentary dispositions. A donated to X, his mistress, the right to receive rentals from his condominium. This falls squarely under Art. 739, 1, Civil Code and Art. 87 Family Code, which declare such donations void if made between persons guilty of concubinage. The defense of A and X, that concubinage must first be proved in a criminal case, is not correct. As settled in jurisprudence, proof of guilt by preponderance of evidence in the civil action is sufficient. Hence, we need not first secure a criminal conviction before invalidating the donation. On October 18, 2022, the Supreme Court en banc promulgated the Rule on International Child Abduction Cases, Rule, which implements the Hague Convention on the Civil Aspects of International Child Abduction of 1980. The rule provides an expeditious procedure to facilitate the prompt return of children who have been wrongfully removed or retained across international boundaries to their state or country of habitual residence. This is based on the presumption that, save in exceptional circumstances, the wrongful removal or retention of the children is not in their best interests. Which of the guiding principles and outcomes under the Supreme Court's Strategic Plan for Judicial Innovations 2022 to 2027, SBJI, are sought to be achieved by this rule? Briefly explain your answer. Nothing follows. The Rule on International Child Abduction Cases advances the SBJI's guiding principle of timely and fair justice, and its outcome of an efficient, technology-driven, and accessible judiciary. By providing an expeditious procedure for the prompt return of children, it ensures that cases are resolved swiftly in line with the best interests of the child, consistent with international commitments under the Hague Convention. It likewise reflects the SBJI's vision of a responsive and rights-based judiciary that addresses transnational family disputes with both fairness and efficiency.